So now that we've understood how you establish a duty of care, we are going to look at the different scenarios where a court has been called to determine whether the duty of care exists or not. Try to go through them as fast as possible, and the rest you can do it on your own by reading, either online or I'll provide the book and you can read. So the first one we're going to look at is a duty owed to consumers of goods. Consumers of goods. This one you got it from Donahue versus Stevenson. Any manufacturer who puts himself in a relationship with the consumer by producing a good and it reaches the consumer the same way it left the factory is liable to that consumer for any injury that would occur or result from any defects in the product. You look at the case of Donahue versus Stevenson, you look at the case of Grant versus Australian Hill. I don't even have to go so much into that. When the goods reach without any modification, the way they leave the factory and reach the consumer, the manufacturer is held liable. If there is a chance for the person to examine the goods before using them, then the manufacturer will no longer be held liable because that breaks the link between him and the consumer. So you look at the case, for example, of Far versus Butters, where this one was buying a crane, and court held that the mere fact that he saw the defective parts of the crane, he knew he was an engineer, he went and still assembled them and used it. When he got injured, they could not sue the crane manufacturer or supplier because the defect had been brought to his attention. Yeah, and then of course the manufacturer should have foreseen the injury. So you look at the different cases, but all those are a duty owed to a consumer of goods. Secondly, we look at duty owed to road users. Of course, this is a common one. Most negligent cases you'll find in Uganda about accidents, car accidents, and there's of course a duty owed to road users. You owe a duty of care to drive carefully and make sure that you don't injure others. For example, if you're driving on a maram road or a loose surface road, you know that you should not exceed a certain speed, like the way you're on tarmac. So you can't drive at 120 kilometers per hour on tarmac and also try to drive at 120 kilometers on maram. If you drive carefully on the 100 and on the maram road, it is fine. But if an accident occurs, then you'll be held liable. You look at the case of Otim versus Nsereko and another. The plaintiff was riding a motorcycle with his father, and then it was on a dusty road. So they stopped, like when you're riding on the road and cars are passing, so they stopped for dust to settle. The defendant was driving his car. The report said he was over 80 kilometers per hour. He must have been like at 100, whatever it was. And when the dust settled, he could not see them. He tried to brake and the car couldn't stop. It was just sliding and he banged them, knocked and killed one of them. And his defense was that these people, I couldn't have known, the road was slippery, the brakes were not working well, the road was slippery. And court said yes. But you ought to have known. You owe the duty on a maram road to drive carefully at a reasonable speed uh, where you can brake easily. But if you're driving at 100 kilometers per hour and you brake and the car slides, you already know that you owe a duty of care and therefore you've breached it in that case. So court found him to be liable. So now the question is, who is a reasonable driver? Should everyone drive for 10 years to be able to be a reasonable driver? Or should there be 6 years? Should you go to driving school for 10 years? For how long should it be? But that has all been settled. The mere fact that you're driving makes you're supposed to be considered by everyone else as a reasonable driver, whether you're driving, whether you're learning or not. Of course, there are policy considerations for that. And but the thing is that you must have the basic skill to do certain things. For example, to brake, how to enter a roundabout, and all those things you learn them in driving school or some of you who drive. So it's not a must that failure to observe the highway code gives rise to liability. It's not a must, but it can prove. Like if you say that do not overtake in this corner, it's not a exact proof that you are liable. What? But when you do the act, and injury, an accident occurs, then it can be used as a basis to determine that you breached your duty of care. You look at the case of Paulo Cato versus Uganda Transport Corporation. It was held that a driver of a motor vehicle is under duty to take reasonable care for the safety of other traffic on the road and to avoid a collision. So everything, if you're overtaking, if you're uh, branching off, you have to take reasonable care to avoid that. And then, of course, drivers have a duty to avoid a collision. When you're approaching, you should take reasonable steps to avoid the collision. If you're on a hill or if you're going down the hill, you should do certain acts which at least show that you try to avoid the collision. And that's what courts have looked at in different cases, which you look at. If you get the notes, you look at the case of Andrea versus Gomba bus service, where a car was strayed on the road, and but the driver just continued driving at the same speed he came out. So he had a duty. You've seen the car crossing the road. You have the duty to at least step on the brakes a bit. If you continue driving at 100 kilometers per hour when you're seeing cattle are crossing, you're no longer acting as a reasonable driver. Yeah. So uh, are all drivers professional? The word professional is used differently in this case, but the thing is that you must do what a reasonable driver should have done at all time. For example, if you're sick, if your eyes are not working, if you go to get in the steering to drive and know very well that your eyes are not working, then if something happens, you cannot use that as an excuse because you don't expect people behind you, in front of you, to know that your eyes are not working. It's upon you. So it's not about professionalism, but when you undertake to drive, you take a duty to take care of that. You take on a duty to ensure that you do not harm other people with your actions. Yeah. So you look at the third one, the duty of people, purchasers of premises. If you own premises, you owe a duty of care to make sure that the people who come to your premises do not get injured out of something resulting from your carelessness. You look at the case of Australian Safeway stores versus Zaluzna. Someone entered, it had been a rainy day, and people were walking, entering the shopping mall. And this person came, slipped, fell. It was found that um, the slippery nature was because of people who were coming, some with clothes dripping, some with shoes dripping, and all that. But the store owed a duty of care to make sure that it either cleaned the place or warned people about the slippery nature. So when you go to any shopping mall nowadays, a shopping mall, I don't know the difference between a shopping mall and arcade, but if you go to a shopping mall or to an arcade, you'll find that there's a warning. When they're cleaning, they put slippery tiles on the stairs, slippery stairs in case it is wet, or in case they're cleaning them, or they're maintaining the building. And that is important. So you owe a duty of care to people who come to you. So the duty owed to children. Duty owed to children is important because children, people below 18 under the Constitution, they are taken to people who can't make proper decisions or people who can't make appraise situations properly. So sometimes situations will arise where the issue is whether a duty of care is owed to them. So a school or any person in child of a child, e.g. daycare, a school, whatever, owes a duty of care to the children while they are under their control or supervision. You look at the case of Richards versus State of Victoria, where they held that it's not just a duty to ensure that harm doesn't occur, but it's a duty to take reasonable care to avoid harm from being suffered. What's important about under the duty of care of children is that there's no unified one type of duty of care, and it varies. So a child who is 3, if you have a kindergarten and your kids, or a daycare and you're looking after children of 6 months to 1 year, 1 year to 3 years, 3 years to 6 years, the duty keeps changing, isn't it? For example, if you're a daycare and you're looking after children who are crawling, parents are bringing their children and dropping them off. You have to make sure that there are no things they can pick up, they crawl in a clean place, they don't fall off the ledge, things like that. It will be different from when you have children who are 3 years who are walking, isn't it? There it will be different. And when you have children who are 3 years, it will be different when you have children who are in 6 years. or 10. It goes on changing according. So it's not a fixed detail. You look at the case of Giliauskas versus the Ministry of Education. Here, children went to a trip, and the teachers told them some animals are dangerous, do not feed them. One child wanted to feed one of a bear. He threw food over. The bear wasn't seeing the food. He climbed over the fence, went to get the food so that he can give it, and then he got, the bear attacked and injured the child. We tried to argue that no, we shouldn't. We warned the children. They are 8 years. We told them they should have known that this is. They said, how can you say that a child should have known? That statement is already dead from the word go. There's no way a child of 8 years could have known, even if you had told him. You still have to take the extra duty, because at that point, children are curious. Those who have children, you know that even if you tell a child, do not put this in your mouth, they will still put it in their mouth. Do not touch the fire, they will still touch it until it burns them. So you can't say that, I told the child not to touch the fire, and I went away. And you come back, you find the child burnt, and you're saying, but I told the child, he's 8 years, he should have known. It can't work like that. So the duty changes accordingly. You look at the cases of Gaya versus Downs, and you look at the case of Jemeo Nasimbwa versus Mubende District Administration. Even children who are older, because someone can say, but the child did the act on his own. In the case of Omara versus Kotido Mixed Primary School, it was a boarding school. The parents took the child to the school, left the child at school. Somehow the child escaped from the school, went to swim in a river with their friends and drowned. And now the parents are home, are being called, your child has drowned in school. They say, how? We brought our child to school. When they tell the school is saying your child escaped. How? There is a gate. How did the child escape? Why aren't you looking after these children? The school is trying to, maybe would have tried to argue that the child managed to beat our security, but no. The mere fact that you're in charge of the children, you're supposed to supervise them and make sure they do what? They are safe at all times. So they couldn't escape liability in that case. Yeah. So there are also certain things you look at, like allurement, things which attract children. You have to be, when something attracts children, is likely to attract them, you're supposed to make sure that it does not get to them, or they do not get to it. Yeah, so the duty of care will be held to exist. So the next duty of care we are looking at is unborn children. Apart from the normal children, born children, unborn children. Is there duty to prevent injury to an unborn child? You look at the case of Watt versus Rama. The Australian court handled for the first time the issue of whether an unborn child could, after being born, later sue the parent in negligence for actions. You have a mother, she's pregnant, she wants to say, Tuliwaweru, Tuliwaweru, she's bungee jumping, or she's taking alcohol. She takes alcohol, drives the car, gets into an accident. Can the child sue and say, my mother was pregnant, she knew she was pregnant, but she wanted to have a TikTok moment to shout Tuliwaweru, and after drinking, she was driving the car carelessly while holding her phone, and we got into an accident. And now my head, I was born with a defect or something like that. Can you sue? In the case of Watt versus Rama, court held it, and it was held that the child could actually sue the mother for the negligent actions. So after, the child could either sue or through someone, and could recover damages actually from the parent. Well, of course, in Uganda it will be rare. I haven't got a case. I don't know a case like that, but it can happen. There must be. We shall ask my visit to look for such clients, and whether he can sue. So you look at those cases. You look at the case of Lynch versus Lynch, where also someone got injured because the child got injured when the person was driving badly. And you also look at the case of Burton versus Islington Health Authority. Because in this case of Burton, many children are being born with disabilities because of negligence of the hospital. So after growing up, they found out that these children had got their disabilities because of the hospital's carelessness. The hospital was held to be liable. Next, we are looking at the duty owed to rescuers. If I do an act and someone gets injured or is about to get injured, and the rescuer comes to rescue him, and that rescuer gets injured, am I liable? And the answer is yes. There's a duty of care owed to rescuers if they do acts which are reasonably incidental to the accident. If you remember the case of the 2018 case, I don't know where you were, 4 years ago, 2018 case where people drowned on the boat cruise. Yeah, the owners of the boat were careless. They let a boat which had been seated for 3 years or something to go. It even had a damage. They didn't care about it. And the boat went onto the lake. Got an accident. It was sinking or capsizing. Someone came to rescue. I don't remember his name. But a fisherman, nearby fisherman, came to rescue with his boat. And many people jumped into his boat and he also drowned. So, of course, this is Uganda. I don't think it was taken up. But that person or his estate could sue the estate of the people who caused the injury, because they should have foreseen that by doing such an act, it was reasonable that nearby fishermen could try to do an act to save the person. You get it? So in that case, the rescuer could be held. Could the defendant could be held to or a duty of care to the rescuer. However, you have to know the issue of reasonableness, because, like in that case of the boat, some people survived the accident. They swam to the beach, jumped on borders, and went back home. Now, if after the boat, someone like was it Desire Luzinda or whoever managed to swim to the shore, got a border, and the border rode at a very fast speed, and then caused an accident. And the border is saying, I was rushing the person home because she was still too scared and all that. That could not be linked, as you cannot say you're a rescuer, and also that proximity between the wrongdoer and the injury that happened could also be too distant, to be too far-fetched, like we talked about. So in dangerous situations, people have to do certain acts to save the situation, and you'll be held liable for what that person suffers as a result of your dangerous situation you've created. There's a case, for example, where someone was locked in the building and in the toilet, and then the person had to try to climb over and all that. And it was held that it was the person who locked was liable, because if you lock someone in, what do you expect? How do you expect other people to react? Of course, someone should try to do whatever they can to escape the hotel. So you look at the cases. You look at the case of Baker versus Hopkins and Sons. Then you look at the case of Wicks versus State Rail Authority of Northern Wales. The next duty of care we are looking at is a duty not to cause psychological harm. Although there is a duty not to cause physical harm, there's also a duty not to cause psychological harm. So in psychological harm, you have primary victims, and secondary victims. Primary victims are the ones who experience the harm itself, whereas secondary ones experience it after the primary ones have experienced it. So it could be someone seeing a friend, a relative, a child, whatever it is. So in this case, there's a difference. If you look at the case of Page versus Smith, the plaintiff suffered from a mental problem, and he was in recovery. Then during recovery, he went back to work, and due to negligence of the employer, he got further injury, further mental problems, and they found that the employer was liable because they knew that he had this situation and they caused further injury by their carelessness. But this was a primary victim because he himself was injured. But where the problem comes in is where it is a secondary victim. What happens? Like a relative hearing that so and so has been injured, seeing it on news, hearing it saying it on Facebook, WhatsApp, whatever it is. what happened. You look at the case of Alcock versus Chief Constable of South Yorkshire. Um, there was a football match, an FA match, in semi-final match in 1989, and you should have heard of it if you watch football when they're talking about the Hillsborough disaster. You should have heard of it. So many people were allowed to enter into the stadium. The stadium collapsed because of the numbers, and people got injured. Now, there are people who got physically injured, and they could be compensated. Those were in the stadium. There are some who died, some who got injured. Now, there are people who are watching at home on TV, and they saw their loved ones getting injured. There are those who were watching the match on TV, and they just saw people dying, and they also got psychological harm. They said, "Oh, we are shocked, we are shocked." There are very many people. There are other people who had it on the radio. There was an accident in the stadium. Over 90 people have died, and they got shocked. Oh, I knew someone who was there, and they got shocked. Now the question was, who can sue in this case? This case came up with, let me say, guidelines to use before you determine who is a secondary victim, someone who is a primary victim, which one can recover. And they said you must have perceived the shocking event yourself. The shock must have been sudden. You saw it and you reacted, not gradual. You watched the match on Sunday. 5 days later, you're saying, "Oh, I had a dream about the Hillsborough disaster, and I'm what? And I'm now psychologically tortured." So it has to be sudden. Thirdly, if the nervous shock is caused by witnessing the death of another person, you must show the relationship. You know, it has to be a serious relationship, like father, son, mother, daughter, parent, child. Okay, husband, wife. Recognize relationships. I don't know if a boyfriend girlfriend would work, or normal friendships could work, but you have to show that there was a very close relationship between you, so that you could react like that. Yeah. And then lastly, the claimant must prove that a reasonable person uh, of ordinary strength, someone normal, could react the same way. Not these people who are chickens. You just see something on TV, and you want to watch with one eye. Not that kind of person. You have to show that the kind of shock that could be suffered by anyone who is reasonable. So those are the conditions they would normally use. You read more from the notes. The next duty of care we can look at is during emergency times or wartime. Now, during times of war, like riots, or like the war, like the ongoing war in Ukraine and Russia, or like you saw during our election times, what was going on, people, how the army was attacking people, and you know, soldiers and policemen were beating up people, shooting. What is the duty of care? So the general rule is that during war, there is no duty of care during a war. Like right now, in in Syria, you can't say if the countries are at war officially. You can't say that when I'm doing this, I owe a duty of care to make sure I drive my tank safely, things like that. I drive at the right speed, and all those things. This is during war. You look at the case of Choiseul versus the Commonwealth. It was held that uh, the Navy could not be liable at that time because there was a serious war of which the naval ships were exchanging fire, and it would be wrong to say that soldiers went to war with a duty also to protect against civil laws. You know, yeah. But of course, you look at other laws to deal with international law crimes and things like crimes against humanity. You shall deal with those. You will deal with those in human rights. But for negligence and a duty of care existing, you do not owe a duty of care at that time. Acts done outside periods of combat, however, if it's not during a war, you'll have to be held liable. You look at the case of Bichi and Bichi versus the Minister of Defense. Uh, during in Kosovo, during a riot, a soldier who was on a UN peacekeeping mission fired bullets at a car and injured people. And then you are saying, no, but we are in wartime and emergency, we don't owe a duty of care. It was held that this was not a war situation. He owed a duty of care before firing at the vehicle to first know who is in the vehicle and all that before he could act. It had to be, he had to take more precaution. Yeah, so you look at the case, the aspect of reasonableness of the action. In Uganda, you saw the case of Omonyi versus Attorney General. You couldn't say it was an emergency situation. There were thugs, they were running around. Still, when you should have known that shooting could cause injury or the duty of care. Even during elections, when the army was firing bullets, live bullets at people, if you injured someone, it's not a war. You're trying to keep peace or whatever. Why are you firing live bullets? So the duty of care would uh, would only not exist when it is a real period of war. But if it is something else, civil unrest and all that, you owe a duty of care to make sure that your actions are careful. So, in the case of Omoni versus Attorney General, I'd want you to read it. Court said it is standard practice that where lethal force is about to be applied, unless the circumstances are such that there is no possibility of issuing a warning, a law enforcement officer is expected to warn the likely victim either verbally or by firing warning shots into the air or on the ground, taking care in the process not to expose anyone to the risk of being harmed. So you look at the case also of Kagwa Vincent versus Attorney General, also in Uganda. There were actions. This one questioned the police officers, and the court said that the officers acted in a really negligent way. They were grossly negligent, let's say. Even in times of emergencies, security officers still owe a duty of care to act reasonably in the circumstances and take precaution not to injure the public or their property. So that's it for in times of emergency. The duty of care exists on security officers. The duty of care of professionals. Professionals, like lawyers, you want to be professionals. We have doctors. They say the oldest professions were medicine, law, and the ministry, religion. But I highly doubt that the ministry is a profession because at least for us, we are governed by a body. I mean, Bujingo has shown us that they can do whatever they want anyway. We leave that, but professionals owe a duty of care if they are acting as providing services to their clients. They owe a duty of care to be careful uh, how they do their work. So whether it is a pilot, whether it's a lawyer drafting documents, whether it's a doctor carrying out an operation, whether it is an accountant doing his books keeping, whatever it is, whether it is a plumber, whether it is a builder, whatever it is, as long as you're in a profession, you owe a duty of care to protect your client from being injured from what you're doing or the service you're providing. Yeah, of course, lawyers, since it is law, lawyers used to escape liability in the old cases. We had what they called barrister's immunity. You'll see it in the case of Rondell versus Worsley, where court first held that lawyers, you don't owe a duty to, a barrister doesn't owe a duty of care to his client. But later on, they found out that no, if someone gives a document to draft, he has come to you to make sure you draft him a proper agreement which protects his rights, and you don't, and his rights are violated, then you owe a duty of care and you can be held liable. Yeah. So that is how the duty exists. You owe a duty of care to make sure that your client is not affected by your actions. In the medical professions, you've heard of it. The medical profession actually, for most the professions which suffer the most are the medical profession because you go for an operation, it goes bad, and people are suing. So you'll see most of the cases on that. And we had the case of Blythe versus Birmingham Waterworks, and where it showed that medical negligence had been used in different ways, but in the medical profession, negligence had been developing over time to this point where they were saying that there was a duty of care. And to understand the duty of care of professionals, they use what they call First, the Bolam test. The Bolam test was developed in the case of Bolam versus Friend Hospital Management, where a court observed that medical professionals, they are not expected to perform miracles, no. But you're supposed to, or they're not even supposed to guarantee treatment. When you go to the doctor, it's not a must that you should heal. It's not a must that you won't die or whatever happened. But he has to carry out the basic practice of a doctor of a profession to give you treatment and at least try to see that you heal or not. So failure to act within the standards of a profession would therefore make you liable. That's what the Bolam test is all about. But this test came into question. You read the case. This case came into question because now professions were saying we are the ones, since we're supposed to act according to what the profession says. If we do what the profession says, then we are not held liable. And this would cause problems. So the later came up with what they call the Bolitho test. In the case of Bolitho versus City and Hackney Health Authority. In this case, the doctors tried to do an operation and they did it according to what the medical practice said. And they were saying, now we have to, you're saying that court cannot question the profession's actions, you know? So in this case, court said no. If that action is also unreasonable or the standards are unreasonable, then court can still question them. Like if you say the standard practice for giving a blood transfusion is testing HIV, testing syphilis, testing Hep B only. Then someone comes for a blood transfusion and they find that there is something else he has got, which is known by the profession. The profession can say that, for us, according to our rules, this is what we check only. That wouldn't be right. So they will question your profession to see whether it was right, what you are doing was right or wrong before you can be held liable. So you read those two tests and you'll see. In Uganda, we had many cases. We had the case of Kimosho versus Wakapita. Court found that a doctor who had totally deviated from the normal practice and clinical guidelines on prescription, he was negligent because he gave a prescription to a pregnant woman. Yet that he's not supposed to do that. He should have first found out that she's pregnant, first found out what the prescription is, its side effects, before giving it. So he was held liable. We also check the case of Honorable Bernard Mulengani versus Attorney General, where it was held that it must be shown that there was a serious deviation from the normal practice. In that case, the lady was giving birth and they were a bit careless. So a professional will be held liable if he deviates from his practice and causes actual injuries. I think I've covered most of them. I've tried to go through them as much as possible, but the rest you should read them on your own at your own time. I can't go through them now, but let me stop there for now.